Hi, my name is John Griffith. I'm a divorce and family law attorney here in San Diego, California. This is one of a series of videos aimed at addressing common issues that come up in California divorce and family law cases. I should note that nothing I say is intended to be or should be taken as legal advice. Every family law case is different. Every family law case has unique facts and circumstances. If you need legal advice regarding your own case, you should definitely talk to a family law attorney. My office offers free consultations. I'd be happy to speak with you about your particular case. Today I'll be talking about responding to a petition for dissolution. When I say dissolution, I mean divorce. California law, or California, calls divorces dissolutions. It's the dissolving of a marital relationship. But I'll reference dissolution as divorce moving forward. So you've received a petition for dissolution, for divorce. Whether you like it or not, your spouse wants a divorce, and he or she has filed a petition for divorce. First thing you need to know when you receive that petition for divorce is whether or not it was properly served. And your spouse is obligated to have someone else personally serve that petition for divorce to you, which is good service, or he or she can have the petition mailed to you, at which point you probably received what's called a notice and acknowledgment of receipt along with it. Now, you're not required to accept service by mail, so you're not required to sign that document that says notice and acknowledgement of receipt and send it back. If you don't want to accept service in that manner and you'd rather be personally served, then you can wait for your spouse or your soon-to-be ex-spouse to have that petition served on you. Regardless, you can't delay the process. If he or she wants to get divorced, then he or she is going to end up getting that petition served on you. Usually it's less embarrassing to go ahead and accept the service by mail, fill out the form and send it back. That way you're not served at work or in front of friends. It can be kind of embarrassing sometimes, which is the reason that we do the service by mail. Now, once you receive that petition and you're looking at the petition, you want to be very careful to look at everything on that petition, because that petition is going to outline what your spouse is asking the court to order in your case. The petition is going to list 1, the date of marriage, 2, the date of separation, which is extremely important. That date of separation is going to set the tone for the rest of your divorce when it comes to how the property and the debts are going to be divided. So if you don't agree with the date of separation that your spouse has put on the petition, then you want to make sure that you put the date that you think you were separated on your response. At that point, the two of you can negotiate with respect to what the date of separation is. Some cases even go to trial on the sole issue of date of separation. And you can imagine why the date of separation would be so important. You're dividing assets. Sometimes we're talking about big assets that were acquired during a couple of months that make a difference as far as the date of separation is concerned. The petition is also going to list all the minor children of the marriage. You want to make sure that your spouse doesn't put one of the children that you may or may not believe is yours. I've had cases before where a spouse had an affair and she listed as one of the children of the marriage a child that my client didn't think was his. You've got to make that an issue in your response and contest the paternity of that child in your response. Or you may find yourself in a situation where you're waiving that issue and accepting that that child is a child of the marriage. The other thing you need to look at is whether or not your spouse is asking the court to make orders for spousal support or alimony and respond accordingly in your response. Another issue that's addressed in the petition for divorce is what your spouse is asking the court to do as far as custody of the children. There's 2 different kinds of custody that are addressed on the petition. There's legal custody and physical custody. And I'll talk about the difference between legal custody and physical custody in a different video. But you want to make sure that you're responding accordingly. If your spouse is asking the court to give he or she sole legal custody or sole physical custody, and you don't want that to happen, make sure that you respond accordingly in your response. So you can imagine there's a lot of things that you need to understand before you file your response and before you fill out your response. You probably want to talk to a divorce attorney if you have any questions about that response, because once you get it filed, it's kind of hard to amend the response. So make sure that you call an attorney to talk about how to fill out that response, or have an attorney fill it out for you and file it for you. Again, my office offers free consultations. If you need help filing a response or filling out a response to a petition for divorce, call my office. My name's John Griffith. I work at Griffith Law. My office is located up in Solana Beach, California. I look forward to hearing from you soon.